There's a body of law that applies to how schools use technology. Schools are legally responsible entities, meaning they are legally responsible to carry out and enforce certain laws. They even are authorized to create their own local law through a school board policy. A policy must be approved by the school board, passed by the school board. It then serves as local law. Someone who violates that law, student or adult, can be not quite tried, but heard in a hearing of the school board and can be required to face certain consequences. A good example is the acceptable use policies that govern how students and adults can use technology in a school. But most school law is state-based. For example, Pennsylvania has laws against password sharing or attempting to break into a network or a secure data area. And there are consequences of thousands of dollars of fines, even possible prison. But there are a few national laws that apply to schools, and that's what we'll look at. Copyright is one of them. But let's focus on the three that address protecting children and families. They're the ones that we hear most about. FERPA, COPPA, and COPPA. We'll learn about each one. FERPA was passed way before computers because it was a way to protect paper records that contained data on student and family privacy kinds of things. So, for example, there are three categories. Some uses of student records are totally prohibited. Nobody's allowed to sell student education record data. Others, there's a caution in their use. So let's say there's a company that generates student report cards. That company has to have access to student educational data, but by FERPA law, they're only allowed to use that data for the purpose of generating report cards, and then they have to destroy the data when it's no longer needed. At the bottom, some things that are automatically always okay is for the student's teachers to access the student data to meet educational needs, only for that use, and for health and safety, in an emergency, to give medical or police staff access to relevant records. I missed one of the circled areas, though. School officials. So a principal, for example, is not automatically entitled to access student records, nor is the principal's secretary. Only if there's a legitimate educational need to do so can they even view them. Wow. So as the internet began to enter schools in 1998, the U.S. Passed a law that is administered by the Federal Trade Commission, the commission that deals with companies. This was in response to corporate websites that collected student data. So the Children's Online Privacy Protection Act, or COPPA, was created, and it only addresses for-profit websites that collect student data. No school or educator or student can violate COPPA unless you host such a for-profit website. COPPA has been enhanced in subsequent years as the internet matured, but it's still mostly aimed at commercial websites so that parents have control over what sites young kids can access. It's been interpreted in an interesting way to provide parental control over what personally identifying information for kids or the family can be posted on school websites or social media and newspapers. Each school district or each school actually can have its own policy to define what information the parents can control in such a way that parents can sign off in advance saying, yes, the school has the ability to post my child's photo and name on the school's website, but no other personally identifying information. The Children's Internet Protection Act, or COPPA, is the one that we hear most about. That's the act that governs internet filtering, what sites kids can access or not. This is a federal law that's administered by the FCC, Federal Communications Commission, because it involves communication like email, things like that. But it's only applicable to some schools and libraries, most of them actually, that get internet funding from the federal E-rate program. So if a private school, a religious school, even a public school does not accept funding from E-rate, they can do what they want here. COPPA does not apply to them. The only penalty for noncompliance is the school loses their E-rate funding. Well, what does COPPA require? So this is an area that most school officials, even who should, and technology officials, should understand that they really don't. So the schools and libraries that are subject to this, meaning they get E-rate funding, are required to adopt and implement a policy. That's it. They're required to adopt and implement a policy. They decide what the policy says. The policy does have to address 5 areas, but it doesn't prohibit anything. So addressing access by kids to inappropriate matter. It could say that this will be under the discretion and control of the classroom teacher, period. Or it could say that we will create a system that blocks all sorts of websites. Safety and security of minors using email, chat rooms, and other kinds of electronic communications. Notice it doesn't say it's prohibited. The policy can say that we don't control this, or it can say that this is left to the judgment of the student, the high school student, or the classroom teacher for younger grades. Unauthorized access like hacking and other unlawful activities by minors. And it can say something like the school district discourages unauthorized access. Or it could say it prohibits it. Unauthorized disclosure, use, etc. of personal information. Okay, that's already controlled by other laws. So the policy can simply say this item is controlled by other laws, and then detail what they are. And finally, measures restricting minors' access to harmful materials. In other words, filtering their internet access. The policy simply addresses it. Some schools' policies permit students to access anything. In other words, there's no filtering system that prohibits their access. So they are expected to behave in a healthy manner and follow their teacher's directions. If they do something that would violate a school code, then that school code can punish them, as opposed to having a technology filter. The school must provide a filtering system that can implement this policy. But if the policy is very, very open, meaning it's implemented, let's say, by the teachers and students themselves, it can be a really minimal filtering system. Or it can be a really intensive, expensive system if the policy has many, many restrictions. So where did all this come from? Well, our culture has changed. So decades ago, kids had only direct access to activities with parents or under parental supervision, under teacher supervision. They didn't interact on their own with the real world. But now with technology, kids in groups, in school, or at home, individually, have access to this big, bad world of wonderful and sometimes scary things. So COPPA actually asks us to think about 3 questions. What is it that we want or need to protect online from our kids? What is at risk if this protection is breached? And if we want to protect it, how do we do that? Let's move on to copyright. So this is a federal law that does certainly apply to everyone in the nation, including schools. What is copyright? It can be explained in 2 sentences. It's a set of exclusive rights granted to the author or creator of an original work. So these are rights that only that author or creator have. These rights include basically 3 things: the right to copy the work, to distribute, and to adapt or change the work. Of course, the copyright holder can assign those rights to someone else or permit someone else to use it, but generally only through signed permission. But are all rights automatically reserved without exception? And are any important ideas really missing from this definition, or is this definition all we need to understand it? Well, let's go back to why do we have copyright? Where does it come from? And the purpose of copyright is really stated in 1 sentence in the U.S. Constitution. And it reads, to promote the progress of science and the useful arts. That's its purpose. The way that it does it is by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. All contemporary patent and copyright law arose from that one sentence. To find more, watch the video Introduction to Copyright. The link is here, but it will appear below the video. I think you'll find it interesting.